2 p.m. by the Bonneville County Commissioners for the purpose of a public hearing in relation to the application of Ryan Loftus representing Johnson Legacy LLC for the rezone from agriculture A1 to residential agriculture RA2. The general location of this is east of the Snake River, approximately 1.5 miles west of 5th West and north of 33rd North, Bonneville County, Idaho. There was a legal description published. Can you scroll down? And which will forego because it will be on the record. And then down to the bottom part, this was published. It gives the access instructions to zoom in because of the COVID, and this was published on July 15th, 2020. Those present, commissioners, Commissioner Brian Reed and myself, Commissioner Roger Christensen. We have planning and zoning staff, both online and in the hearing room. To begin with, a few administrative things because of the failure of the equipment when we went to Steve went to review to start working on findings. There was no recording. All of the documentation that was submitted before in that hearing and the planning hearing without objection like to make part of the record. Okay. So the purpose of today, you will have the opportunity to supplement that record. A lot of that we don't need to go back over. Hopefully you can summarize on the points that you want us to consider as we consider this hearing along with the record that's in place. So to begin with, we'll have Mr. Loftus. You can probably do it from here or this seat back here because the owl picks it up pretty good. Go ahead and present your case summary, however you want to present anything that you want on the record.
Super. Thank you very much. As you mentioned, Commissioner, this is a request for rezone from agricultural to residential agricultural 2. And I'd like to just read from the county ordinance what the purpose of an RA2 zone is, what the goal is. RA2 Rural Estate Zone is established to encourage the orderly and timely conversion of certain land areas into residential areas as the need arises. It is anticipated that this RA2 zone will be applied to those areas of the county which are still rural in character, but which have a definite residential potential. To accomplish this purpose, large lot areas and open space will be required to correspond to the rural character, while at the same time permitted uses and activities will be controlled to ensure a high standard for single-family residential use. That is a different statement than what's on the RA1 zone. And the RA1 zone is meant to be medium to small lots. It doesn't say anything about large lots or small lots. But from RA2 through RA4, and those lots get bigger as you go with higher numbers, it mentions large lots. The minimum lot size for an RA2 zone is 1 acre with 100 foot of width. All of the zones have a 20-foot height limitation. So we're requesting the RA2 zone with the proposal that those lots will be close to 2 acres in size. They'll average about 2 acres in size, which is almost double what the minimum is. The other zones that would be considered in this area, just by comparison, RA3 requires 2.5 acre minimums with 158 foot lot width. RA4 is a 5 acre minimum with a 200 foot lot width. For comparison, the Heritage Hills subdivision that's located east of this development in the city of Idaho Falls has lots that are in the Let's see, my glasses are too foggy. They're in the lot size of 0.138 to 0.375. So they're less than a quarter. Their largest lot is less than a quarter the size of our of the RA2 zone. In the ordinance, it mentions that all of the sewer and water has to comply with state and county ordinances. We can get individual wells and individual septics on lots as small as 0.6 acres. We're not proposing that. But my point in this exercise is to point out that the RA2 zone is appropriate for this area, particularly with the riverfront properties. They're larger lots. They meet that classification by almost double. And it will be a good transition from those city lots to the east into this zoning that's west of it along the river. I should note that the groundwater is more than 100 feet in depth below the surface, which allows for great treatment of septic systems if needed, and would meet all the requirements of the health department. I don't think I've got anything else at this point, but if you have questions, oh no, I need a couple other things. I need to mention that the reason that my client is here is because of the actions of the city of Idaho Falls. In January of 2019, they passed a moratorium for the airport area. And that moratorium on January 31st of 2019 effectively stopped all of the building in that area in the city. Subsequent to that moratorium, and because of that, and the purpose of the moratorium was to change the comprehensive land use plan. And that comprehensive land use plan was changed on May 9th of 2019. Do you need those minutes from that city council meeting?
I would like to have those be part of the record.
It's 314 pages long, so a portion of them.
Do you want to email me the rest?
Pardon?
Do you want to email me?
You bet.
Okay.
You bet.
And I'll get those to you.
And that comprehensive land use plan effectively changed what was allowed in this area to educational use buildings. Now they have a list of things that could be approved, but there's no guarantee or even an inkling that anything residential can go into the city's requirements in that district. So that leaves my client not being able to annex to the city and develop this in the county instead. So with that, any questions?
What was the date of the first application?
The first what?
Your first application to the
Yep,
planning board?
It was in,
We can look it up. So.
I think it was December, no, it was, I got it here, hold on.
I thought it was December 19th.
I signed it on October 29th. So it was first heard on November of 19.
Okay, thank you.
I've got a question.
Sure.
You mentioned at the end that he's not able to annex into the city now because of that plan change, correct?
Let me clarify that. He could annex, but he could not build a residential subdivision in the city of Idaho Falls in that location, based primarily on the comprehensive land use plan. It would be out of line with the city's comprehensive land use plan. It is in line with the county's comprehensive land use plan for urban residential development. It doesn't match anything in the city. I don't know if the city and the county coordinated on that plan. This area is in the impact area for the city of Idaho Falls. And I would think that normally those adjacent jurisdictions would have a conversation and say, hey, we're changing our comp plan. How does that match with what you've got? I don't know if that happened or not. It appears to not, but now there'd be no residential allowed by that new comp plan in the city of Idaho Falls.
Okay, thank you.
I may have some questions on that a little later, but I'll hold those. Okay. You'll be free for questions now. Do you have any other new documentation that you would like to put on the record other than what's already been submitted?
No, those city notes from May 9th of 2019 are what we need there.
Okay, Mr. Johnson, you're part of the application process. As an applicant, do you wish to stay before we open it up to testimony?
I would like to make your statement.
Sure.
Thank you. I'll step up here at the table, so I have a place to say. Yeah, I understand.
Unless you need the table.
I want the table, so thank you. I understand these pick up with that. May I proceed?
Yes.
Identification for the record, David A. Johnson, business address 477 Shoup, Suite 205. I am here both as a managing member of Johnson Legacy LLC. By profession, I am a licensed attorney at law in the state of Idaho. Primarily what I'm going to be doing is responding to what has been submitted to the city. I think as an overview of the situation, I would first note that what is being proposed is very consistent with the comprehensive plan of the county as well as surrounding lands. Is that there was many supposition raised by the city in a December 2019 letter by Mr. Kramer that talked about that in somewhat the negative light. But let me indicate we have been in contact, in close contact, with all of the surrounding properties, including the Mickelsons, Burton Shaw, who owns a property to the east, Dave Kingston, and so forth. They're very much aware, and they certainly do not have any opposition has been represented to me regarding the same. What we propose.
Interrupt you real quick. That record from Mr. Kramer is part of the record from the last one, as I recall.
Yes.
Okay.
What we did get the records from Mr. Sear and Planning and Zoning. Was not given directly to us, but we did subsequently get that. I was unaware that it had been previously submitted, but I am familiar with that. I would note in particularly that our proposed subdivision matches up very well as far as consistency with the River Acre Estates. That's basically approximately a third of a mile north of the north boundary of ours, if that makes sense. The property between ours and the Mickelsons is the one in between, and they themselves are basically aware of it. And so it's a comprehensive plan. This is not a subdivision in isolation. I would also note that also in that area to the north is Fairway Estates, which is a city annex property, arguably that came in by a shoestring annexation, but nevertheless is that the property surrounding ours is all residential based property, or at least how they were planned in the past. Now, addressing Mr. Kramer's letter, first of one of the areas he argues is that there should be an area of impact imposed in this area that would require us to go to and seek annexation of the city. It needs to be very clear that there is no such agreement that has existed in the past. I don't know if there has been some recently created, but the argument made is they're trying to say that because there has been discussion, that is the equivalent of an agreement. And that there shouldn't be any public input, anything related to that. What our application is at the present time is very clear It's a request for rezoning. After we get the rezoning, then we would be looking at a plat map, and we would even be willing to look at specifically how we can reasonably accommodate the city's request for approaching and departure of aircraft. It would be our expectation that there also be reasonable compensation by the city in that conversation. But there is no requirement in the law that says that we have to apply to the city either for approval of our subdivision or to otherwise, and more particularly, to become annexed into the city. Probably the most troubling part of what we have is the city is not acting primarily as a regulatory agency. It is not acting in this case, as they described it, as a way to manage growth in a responsible way. They have been candid to say the reason they're opposing this is because of their pecuniary interest in the Idaho Falls Regional Airport. They've been candid in saying that the reason they want to stop all residential growth is because in doing so would prevent them from realizing future FAA funds and perhaps even a requirement of repayment. I would submit that that is not a legitimate recognition of what this of this commission's responsibility in this particular area. Usually when you have somebody that has a pecuniary interest in the law, it requires a reclusal. If it's somebody that sits on a commission or panel or council, it's an abstention. But that doesn't apply in this particular case, but there certainly is a conflict of interest and an ability to act impartially on the part of the city. And that is a problem. Now, when you make the argument that we should approach the city and to be able to see what they do, is I think it's fairly clear that it's going to be dead on arrival. And obviously we've had to look at other recourse, and it's why we are before this commission at this time, is because we know that they are not going to allow any residential development, not based upon economic criteria, not based upon plan, but simply based upon economic factors. Now, Mr. Kramer in his letter talked about 50 land uses that are permissible. I would first note that there is some inconsistency in the material he provides. First of all, part of the uses which they said are allowed would be schools and hospitals. And yet in the FAA material that they provided to the commission, it says those are things that should not be there. There has been many meetings that have been conducted and which the city has listened, but the question is what have they been able to do? There has not been any consensus between the city and any of the stakeholders that are involved in this particular and affected area. There has been no showing that any of the uses that are proposed would have any economic viability. And that's a problem when you're talking about managing growth in a responsible way, is we're looking at what is the needs of the community, what you're looking at as far as what is going to provide society as a whole their best interest. Now, we can argue, and I could understand the argument of the need of an airport. And I'm not getting into whether or not the airport should move, but the fact is this is a classic example that many cities have faced in the past, is where you have an airport that is developed close to a developing area, as far as residential, and you have competing use. But it really does come down to two different viable options. One is to move the airport. The other is to acquire the necessary rights. The inappropriate manner is trying to make a regulatory taking by using regulations in order to prevent the proper development of property. And that's large part of what we're talking about, is they're trying to say to this commission is you should defer to them. And then they'll make the decision what we have, and you're not going to be liable for any regulatory taking. That is not an option that we consider viable as far as what we see going forward. Now, the argument which they also made is they talked about spite strips. It's a term that I heard for, frankly, the first time as they raised it in this case. As far as that is concerned, first of all, a spite strip, as I've researched, is a 1 to 2 foot strip in order to have certain viability. That isn't even an issue that is before this commission at this time. There is not a submitted plan to this commission. When we presented it to the planning and zoning, we could see that maybe there were some things that we could improve on before it advanced. And so we tabled that and proceeded with what we did. Now, did we predict the somewhat comedies of errors that we had, including the lost tape, the COVID, and those type of things that have happened in this case? But nevertheless, that is what the approach is that we're taking, is that we are going to do what's right in the plat to make it viable for everybody, and including any of the cities concerned, to see if we could hammer those out. Next point is in regards to utilities. The city makes a bunch of kitchen sink arguments to say that why this should not be approved. However, they've never explored any of those factors and are asking this commission to speculate on some of those. First of all, they argue to say power cannot be provided. They did clarify that it said it should be power from the city of Idaho Falls. Well, there are other providers of power, and I'm sure that it can be well established. This specific court has power lines on the south side of 33rd North. Idaho Falls has them on the north side of 33rd North. So power availability is substantially equivalent, regardless of who the provider is. I also find it interesting, the argument they talk about sewer and water, and that it would be terrible to have all of these different septic tanks. As Mr. Loftus has indicated, that there has been studies to show that that would not be an environmental impact, that the microbes and other mechanisms would not pose a risk. It is the Department of the Eastern Idaho Health Department who would be responsible for regulating that safety, and not the city of Idaho Falls, who apply rigid standards for the protection of the community. I would also note the argument that they say that they could not provide city or any city utilities if not annexed. I would disagree with that point. They can if they want to. But really what their argument is that we won't because we don't have control. And that is a different one. So there's somewhat of an indictment there. If they are concerned about that, they can have the ability to cure that by a contract on adding on. In the law, that is something called estoppel, is you can't take inconsistent positions in a particular situation. Now, this moratorium and other thing has been going on for 19 months. We've had numerous meetings which really have not resulted in any significant compromise. is that the proposals and the layout have been strictly the city's. They might as well have told us to build a cricket stadium than some of the uses which they say is permitted in that particular area. I would indicate that the city has also indicated that they had no money to acquire the land. And that's a problem. But for us as private citizens, to hear them saying they've got $12 million for the airport, but they're getting that at the expense of particular individuals, that defies their laws as far as just compensation or unlawful taking of property without proper things. I would also note that the last hearing is that there was some statements made about what the city has regressed in their position, where they say they have yanked back subdivisions. I went back and looked at the record, and I would refer the commissioners to page 40 of the planning and zoning record in regards to Mr. Burtonshaw's testimony. Mr. Kramer was correct in saying that they allowed the development of the first phase, which was the only final approved one. But there was also 3 divisions or subdivisions, 3 divisions of development, 2 of which were withdrawn. One of the basic tenets of development is that your infrastructure costs are fixed, they're up front. And you don't make money until you sell your last lots. And also in conjunction with that is representations were made to Rockwell Development, who acquired part of the farm, the Mickelson farm to the north. And basically because of that there was significant modifications to what was represented to those individuals as well. I would also note the final aspect is they talked about the International Fire Code and saying that this is a dead-end property. I can tell you that I had conversations with Renee McGee, Mr. Kramer's predecessor in interest, when the preliminary plat of Heritage Hills was being developed. And we made representations that we would work together in order to provide 2 different alternatives if that was necessary. I've also would indicate that we have made communications with the surrounding property, as I said before, and those issues are not an issue, and they can be addressed when we submit to the plat for consideration. Thank you. Does any commission have any questions?
I have a list, but I'm gonna wait till city representative what they have to say.
Okay.
If you would excuse me for about 60 seconds. Let's let the day go.
May I go back to one question for Mr. Johnson?
Sure.
Mr. Johnson, just the only thing I wondered is if you understood that there could be restrictions from the county because of the proximity to the airport. Do you acknowledge that
Oh, yes,
and understand that?
I do.
Okay. All right, thank you.
Yeah, I'm glad you pointed out that. That's, because it is in our jurisdiction and we can find a reasonable accommodation that we believe fills the needs of looking out for the airport and also protecting the private property.
Right, and we recognize it's actually a statutory duty of the county commission.
Right. One that we love most of the time. Okay, the only other members of the audience I see other than on Zoom, and they may want to testify later, are representatives from the city of Idaho Falls. Who wants to lead off, or
Here or here?
Depends on how loud or whether or not you want the table.
I don't need the table.
Okay.
I don't need the table. So for the record, my name is Brad Kramer, address is 680 Park Avenue. I work for the city of Idaho Falls in the Community Development Services Department. I don't intend to repeat everything that was said at the first hearing. As you requested, I would make a couple of summary points and then address a number of statements that were made during the other presentation. You may also have questions for the city, I'm sure you do. I don't intend to answer the questions specifically about the airport. That's why Mr. Cloutier is here. If there are any legal questions, that's why Mr. Fike is here, but I'll do my best to answer planning and zoning related questions. The summary points that I would bring up is why the city is opposed to the rezone. First of all, we are the airport sponsor. The city of Idaho Falls is the airport sponsor, and it's our responsibility to protect the current and future viability of the airport. We know from conversations with the Federal Aviation Administration that there are concerns about residential properties being developed underneath these approach zones that have been discussed already. So that's what's put us here. But if I even take out the airport issues, I would start with a summary point that we would request you consider, that the area of impact agreement is in place, just not the one that was quoted in that letter. So let me read directly from the current area of impact agreement that has been signed and adopted by both the city and the county. It states all land qualifying for annexation when proposed for development should be annexed and developed in the city of Idaho Falls unless the city chooses not to annex such lands. That is what the current agreement between our jurisdictions says. It is clear that this property is being proposed for development. No one has shied away from that fact, and it's also clear that this property is eligible for annexation. So based on that agreement that we both signed, that the land should be developed and annexed and developed in the city of Idaho Falls, unless the city chooses not to annex. Now, at the P&Z meeting, I did bring this up, and it was pointed out to me that the word is should, and I completely understand that the word is should. But if we're not giving due consideration to those agreements, I'm not sure why they're in place. So that would be the first point that I would ask you to consider. The second summary point is to refer to the county's own comprehensive plan when it relates to the airport. And I bring the airport up again because the question before you is whether or not this zone change makes sense. You've heard some arguments as to why it does. I think there's some arguments as to why it doesn't. And part of it is because of its proximity to the airport. In the county's comprehensive plan, page 8 states that one of the strategies of the county is to protect the public investment in Fanning Field, the Idaho Falls Municipal Airport, as well as the safety of aircraft pilots and passengers. We know, and I'm sure Mr. Cloutier will point this out as well, that allowing residential development in an area where planes come as low as 100 feet above a property, both in terms of noise, proximity of those aircraft to the ground, the frequency of aircraft that are going to be coming in and out of that off of that runway, is not a good protection of its future, of that airport's future. The FAA has told us this, their guidelines tell us this, and so consistent with the county's plan to protect the airport, rezoning this to a zone that allows a greater density than what it currently allows does not protect the future viability of the Idaho Falls Airport. The third summary point is that just in general, again, based on the county's comprehensive plan, this location does not make sense at this time for higher density residential development. In your legal notice, it points out that it's a half a mile west of, I want to call it East River Road, the fifth east. That's a half a mile of road that must be developed and improved in order to even access this property. The county's plan for the suburban mixed use area, which is the designation for this particular property, is clear that it does want to promote development where central utility systems are available. Now, IF Power was referenced. The only reason I referenced Idaho Falls Power couldn't provide service was because the plat map that was submitted to the P&Z referenced Idaho Falls Power as being the power provider, which was inaccurate. I was trying to point out that that wasn't an opportunity, a possibility. But in the county's plan on page 9, for the suburban mixed-use designation, it states that it's designed to promote facilities and services, particularly water and sewer systems, to all areas as development intensifies, that they would be serviced by a secondary treatment plant, that they would provide all residents of urban areas with sewer systems. These kinds of policies continue throughout the county's plan for the suburban mixed-use area, which is the designation for this particular property. And in the testimony given by Mr. Loftus, he mentioned a couple of times the phrase rural in character, that is the appropriate place for an RA2 zone. I would ask if an area where airplanes are going across the property at a very close level is rural in character. The smaller lots referenced to the east in Heritage Hills suggest that it's not a rural, it's becoming less of a rural area as property continued to develop. The large research park where INL facilities and ISU facilities exist to the south are certainly not rural in character. I bring all these up to point out that there are some, yes, there are some arguments as to why this makes sense as a rezone, but there are certainly a fair number of them that suggest that this is not the right place nor the right time for a rezone. I would like to point out just a couple of things just in response to some of the testimony. The reference was made to the comprehensive plan that it was amended in May to show higher educational facilities. That's accurate. However, what was neglected to be stated is that prior to that change, our comprehensive plan designated that area as open space, recognizing from 2013, this would be an area that would be difficult for residential development because of the noise of the planes. So that was 7 years ago. That change was made. So in our mind, and I think even if you were to read the testimony, the change to higher education facilities increased the opportunities in our mind. Now, whether or not those are economically viable today or not, it's a different designation that allows more possibilities than the open space did prior to the May 9th meeting. The statement was made that the moratorium has been going on for 19 months, so I'd like to correct that. The law wouldn't allow for that. The moratorium was lifted after a few months before the statutory deadline to lift the moratorium. The codes were changed, certainly in the city of Idaho Falls, to prohibit residential development in certain sensitive areas, and those regulations remain in place, but there is no moratorium anywhere right now in the city of Idaho Falls. Make sure I cover some of the other responses. I believe that's all I want to say. I think you have the rest of our record. We would just submit the prior information. We also did supply a jump drive with a lot of documentation that was referred. I'm assuming you've received that documentation as well from your planning staff. Be happy to answer any questions that you may have.
Yeah, I do have a couple. You talked about how it should be annexed by the city. Should, I think, is first you said shall, but then should is the correct word on that. But how long have you had to consider the annexation? When the discussion first began with the Johnsons and you about annexation?
It has not, because they've never submitted an application for it.
Well, the question is, how long have you been aware and had conversations with them about annexation, try to work something out?
Work something out about annexation?
Yeah, have there been ongoing conversations for 2 weeks prior to this, a month prior, a year prior?
No, it's not our, it's with the exception of the project we went through to annex properties that had utilities outside of city boundaries. It's not been our practice to approach landowners about annexation, especially if they have an existing application within the county to rezone and develop within the county.
Did the Johnsons ever approach you prior prior to this? To
About-
see if the property would be annexable?
I don't recall having any discussions with the Johnsons about eligibility for annexation. No.
Okay, and on the comprehensive plan change, you know, 'cause, the spirit of that agreement is to try to get ours per year. And I think it's been stated before that, yes, we do have airport restrictions in those, in the current comprehensive plan. Where you changed yours in May, was it May of 2019? Did you ever approach the county planning commission, which is where it starts, and have discussions on getting them to change the county comprehensive plan to mirror or resemble what the city of Idaho Falls has?
I took two approaches. So yes, thank you for asking. I did along the way throughout our moratorium and our discussions about amending our code and plan. I kept the county planning staff informed, sent them emails of what we were considering the latest iterations. And if you'll recall, I met with the county commissioners to discuss what we had done during our moratorium and asked you to consider what would make sense for the county to do. I never heard any response. I know that our representative liaison between the two P&Z commissions brought it up at least twice that he referenced as something that needed to be discussed, but to my knowledge, has never been put on the agenda. If I need to follow a different route to have those discussions, I will certainly do so.
Well, generally, in our past conversations, I've indicated that you need to start at the planning commission level and have the planning commission meet with our planning commission to help develop something that's compatible before. It's a more healthy process if you want to get something that we're going to agree to do that up front before it's adopted by the city council or the county commissions. Did you ever do that?
To get the two elected bodies together?
No, the two commissions together prior to taking it to the city council.
Not to talk about this issue, because of the time clock, the time sensitive nature of a moratorium, my job, as I saw it, was to keep the county informed of what we were doing and get our moratorium lifted. That was my goal.
Okay. That's other questions that I'm sure will be coming. On the change you made in your plan, you said the purpose is try to discourage density in those areas in the airport path. What's the density that's allowed on the changes that you made?
Well, in terms of residential in those areas,
Not
there is
residential, just in general, because I think density is density. You know, when you're talking about the safety portion of it, I understand it from the other hearings that noise conditions, you know, we've got all the maps showing the different noise decibel levels. What densities would you be allowing in that area, say, to the closer to the airport?
So I guess when I think of density, I might just be interpreting it a little differently. I think of number of units per acre, but we don't have in the commercial types of uses a restriction on, say building footprint per acre, but we do have standards that regulate height, and we keep the buildings off of the center line of that runway. So if there ever were an accident or a plane that needed to land on that approach to the runway, there would be a clear path. There wouldn't be buildings or trees in the way. So we do have some standards in making sure that the buildings are outside of the most sensitive areas that we need to protect.
Commissioner, if I could, on this same subject, so that zone that the Johnson property falls into is designated as limited development on your comprehensive plan, correct?
Not on our comprehensive plan, no.
Or is it designated as no development?
You're talking about our zoning ordinance.
No, so the airport overlay map, it has those zones. Which zone is it designated as on that?
I believe, I don't think it's limited development. I don't have the code in front of me now. It's either limited development or limited development approach or controlled approach.
Okay.
Limited development approach.
What you show
Right, the approach.
on the document we have on record.
It's limited. It's one of the limited developments. I couldn't remember which one it was. I just wanted to clarify.
But we do have that.
Yeah, we have that on record. So.
Okay, then we'll review that. But your you're basically saying the main concern is on the direct flight path or to try to come up with conditions to, for safety reasons to keep those out, accommodations for that in your zone, but you have no density requirement.
For commercial uses, that's correct.
So you could have it, you know, with 200 people per acre. Like an office building.
Well, actually, no, because the types of uses where you're going to have a close assembly of people. So I think we're talking about two different things, right? So if you have, say, an event center or a theater, right, where large groups of people will be congregated in the same place, those kinds of uses are not allowed in these approach surfaces. Right now, an office building that may be spread out over 60,000 square feet, could there be 200 people in there? Sure, but they are spread out far more than say, in a theater or some sort of auditorium.
But still, if you're talking about a density per acre, what would be allowed?
So the only, in the model code in our plan, the only reference to density and people per acre is that I believe it's 25 people per acre is what it recommends. But it's, again, it's referring to residential uses.
But well, I guess help me understand what people on people, if they're there, under whatever the zone is.
Sure. So of course, people are people. But we have the safety considerations that we've talked about, keeping things off the center line. And we also are regulating for nuisances, and that's where the noise charts come in. So typically, in that residential environment, the nuisance levels, we were certainly more sensitive to the folks that are trying to live in close proximity to the airport. In industrial, commercial buildings, there's a different construction standard. People are only there for a certain number of days. They're not trying to sleep predominantly in those areas. Now, we've referenced hospitals and schools. I recognize that. Rick and I have already talked about going through that land use table again. Remember, this was done very quickly. Normally, we've never changed a code this quick, but we wanted that moratorium lifted. So we did our best. We protected what we were absolutely sure of needed to be protected. And we have full recognition that we need to go back and revisit this and make sure we clean it up even more.
Well, and just to make sure I'm trying to give the information to look at what's reasonable accommodations. And this is the zoning. It was pointed out that the plat map that came up was withdrawn. So, and that was a good point because that's not part of the hearing, it's what the plat is.
Sure.
This is a zone hearing. Let's see, where was I going with that? Just to come up with some of the issues that you would consider to help mitigate. For example, if you had a building construction and you know the noise, and I think this was presented by Steve Sear, you know that the sound is coming a certain direction and a certain amount of decibels, you could maybe require fewer windows or insulation on those, again, possibly a requirement to build them away from the glide path. That's why I'm trying to understand what the concerns are that we need to be considering. Go ahead, I need to go through these and make sure I've got.
Did you restate what you said about the green space? When did that happen?
In the comprehensive plan.
Yeah, when was it determined that area would be green space?
So that was from the comprehensive plan map that was adopted in 2013.
Okay. And I guess that with that, I couldn't remember the date you said, but it brought to mind, has the city made any attempts since then to purchase that, recognizing that that is going to be needed, that is green space, the landowner probably has expectations?
If it's okay, can I defer that question to Mr. Five? Would that be okay?
Sure, he'll have to sign in to testify, but
Yeah, and we'll have him present whatever he's going to present, and we'll save those because I have some other questions.
okay, that'd be fine.
Okay, thanks, Brad. Who's next? Mr. Cloutier?
Cloutier, yes, sir. Good afternoon. For the record, my name is Rick Cloutier. I'm the airport director at Idaho Falls Regional Airport, 2140 North Skyline Drive, Idaho Falls. As Mr. Kramer started out, I mean, I am not going to be here and, you know, relay all the information that's been at previous meetings before. I would just like to make a few points and answer any questions. You know, I'd just like to make a statement that a zoning change to residential would cause a significant impact to both aviation and land and residents in this area. As we discussed in previous meetings, aircraft would be flying over that area on both approach and departures between 75 and 150 feet above ground level. With this, please keep in mind that on departure, aircraft engines are at full power till they reach at least 10,000 feet. So it would be very loud in that area. And with zoning, Chapter 35 of the current county zoning ordinance establishes an airport zoning ordinance for the area. I'm sure you're all familiar with this, but I'd like to just read a few statements from that declaration of purpose, if I could, for the record. Chapter 35 Airport Zoning Ordinance, Section 1-30350, Declaration of Purpose. Whereas the public policy of this state is declared to be that any hazard to the safety of air flight may cause disastrous and needless loss of life and property, that safety in air flight is of paramount importance for this protection and well-being of the people that use of the airspace, and this airspace is consistently increasing and is vital to the continued growth, development, enjoyment of the great natural resources in the economy of this state, and that the general welfare of the citizens of this state requires, under police powers of this state, that the maximum safety precautions to air commerce be enacted and maintained. Whereas it is hereby found that the airport hazard endangers the lives of property of the users of Fanning Field Airport and the occupants of any land or property in its vicinity, and also of the obstruction type in effect reduces the size of the area available for the landing, takeoff, and maneuvering of aircraft, thus tending to destroy or impair the utility of Fanning Field Airport and the public investment therein. It is declared that the creation or establishment of an airport hazard is a public nuisance and an injury to the region served by Fanning Field Airport, that is necessary in the interest of public health, public safety, and general welfare, that the creation of or establishment of airport hazards be prevented. That the prevention of these hazards should be accomplished to the extent legally possible by the exercise of police power without compensation. It is further declared that both the prevention of the creation or establishment of airport hazards and the elimination, removal, alteration, mitigation, or marking and lighting of existing airport hazards are public purposes which political subdivisions may raise and expend public funds and acquire land and interest. So
What's your source on that?
that's the county zoning ordinance,
So we have that.
Yeah.
chapter 35. And there's many pages of that zoning ordinance, but it does go on there to state that any impact of future development that may impact the development of the airport should be mitigated against. And having residential property is incompatible land use to the FAA guidelines and could cause us to not be able to grow the airport, would require us to shorten the runway length, we would lose aircraft. So anything like that could impact the future growth of the airport, which is a vital resource to the community. Just in closing, I would like to state that it's my opinion that a rezone goes against current established county zoning ordinance. If approved, this create a hazard to both aircraft navigation and possibly limit the growth of the airport. This also causes risk to residents and people living in this area. If approved, the likelihood of increased complaints and legal action from residents to the airport the city and the county for allowing approval of this change. And I can answer any questions.
I'll go first this time.
Okay. How does a residential area affect navigational safety? I didn't follow.
It's in the FAA guidelines, residential areas in our approach areas. This is our approach zone of the airport, is an incompatible land use due to noise, safety, complaints. I mean, it just causes problems for the future of haters at the airport when large aircraft are coming over your house at 75 feet.
I understand that part of it. I don't understand how it creates a navigational safety issue for the aircraft.
Lighting, uses of the residential property with different types of light that we can't control, things like that.
Okay. And is that is an FAA? Is that, would I find that in the
Yes,
FAA?
yeah, and I could send you some information if you'd like.
That's really the only question.
How far away is a plane when it reaches 10,000 feet?
It's about 50,000 feet away from the airport, roughly. Depends upon the weather and departure patterns and things, but
And there's 5,208, so that's 10 miles away.
yes, it could be up to, it depends upon like I said, the aircraft itself, things like that.
Because your concern was, as you stated earlier, was as a plane takes off, that whole glide path and the noise all the way out to, you said, 10,000 feet.
Yes.
Right? So you're saying that for 10 miles, there should be some type of consideration?
No, sir, I'm saying for within our designated approach areas, it becomes more of a concern because the higher you get up, the less you're gonna hear them.
Okay, and how high up before you, and I think those tables are in the airport study that
Yes,
show
sir.
how far and then the PV levels, okay, we can look at those. In the ordinance you read to the county, it talked about a lot of concerns and restricting in the future use and growth of the airport. In your opinion, do you think that the changes that the city has already allowed at the end of that runway with all of the INL buildings have already restricted that?
No, sir, because currently, those INL buildings are far enough to the south that doesn't really affect our approach surfaces, and they're not considered incompatible land uses because they're industrial, commercial buildings that are far enough away that I think would not impact development.
And one other question I remember from the prior hearing, you do allow schools and churches?
Well, and that's the same discussion we just had. Mr. Kramer mentioned to you that, just like anything else, if you try to do too quickly, you sometimes make some errors. And we realize that we erred in that, and we are going back and changing that at this time. It will not allow schools and churches.
Okay, but the change you proposed, realize we're operating under
Yes, sir.
under the conditions we were under.
But schools and churches, they're not there 24 hours a day, and they're not trying to live there and sleep. And those schools and churches are not allowed on the approach paths at all.
And then one last question, and we do appreciate that, I think, Randy and your staff was here last time, when we talked about a records request we had. They did provide us some of those, like, plans and things. One of the things we had asked on that was for any correspondence, email, electronic, anything between you, the elected officials on the airport's conditions and plan, and the FAA. We haven't received any of that. No electronic emails, or
We've given you all the information that we have.
you don't have any emails, you never corresponded in writing? with the
Not
FAA?
since after this. Yes, we have, but not since after the last meeting.
No, our request was prior to the last.
No, sir, everything with the FAA is done in meetings, face to face, verbal.
Is verbal.
Yes, sir. With the exception of recent events which required us to social distance from each other. They have changed their policies, I guess.
Okay,
A question.
yeah.
I'm still having a hard time understanding the safety issue, because you just said, you told me that the lighting that you can't control in residential was a safety issue. Is it not arbitrary to say that commercial buildings, everything that INL already has there, does not have the same lighting, possibly more in parking lots and everything?
No, it doesn't, sir, because anything that we can control in the city is required to meet FAA lighting standards of certain height of the light. They're shielded from the top. I mean, there's all kinds of things that have to meet standards for all the lighting there. They're shielded lights. They're not set alone. They're things like that we require them to have.
Okay.
Question or comment from the zoning office. So one thing that we have a question or want to put on the record, in the compatible uses in the airport overlay zone, it says residential densities must be less than 9 units per acre for areas of parcels located within the 65 decibel limit on the IFRA noise contours map, which was what has been submitted in the previous meeting. We show that parcel is less than the 65 decibel limit on that map. I understand that it's not in your allowed use. It doesn't fall under, a portion of the parcel falls under limited development, which would allow for those 9 units per acre on portions of the parcel because they're not in the approach surface. Just going off of that, I guess the noise keeps coming up as a repeated issue in these hearings, and we're not sure why that noise is a repeated issue. When it's
Because
less
those
than
noise
required.
decibels are over a 24-hour range. So
Okay.
they're the average of 24 hours. So there might be 8 hours a day that has no airplane noise, but you average out when that plane goes across at 75 feet. Are you still going to like that over your house, even though it's only 15 times a day? But
Right, and I understand that. We're just saying from what the study shows, it shows that area is less than 65 decibels.
because that's an average of 24 hours.
Okay, so that's what we're going off of for saying in the Idaho Falls ordinance, it allows for 9 units per acre in those areas.
Yeah, but that's a previous, and Mr. Kramer might be able to answer that better. That's a previous
Okay.
zoning,
Okay, that's just something that we wanted to bring up.
not our most current zoning.
That is correct,
Clarification.
but it's not in the approach, so
Okay.
there are parts, there's, sorry,
Previous meaning prior to the change.
no, that's current, that is current zoning regulation.
Okay, after you changed it.
It's part of the airport overlay that we adopted as part of the moratorium.
Right.
What I think is being suggested is that there is a portion, a small portion of the Johnson
Right
property
here.
that is within that yellow, yes, that allows 9 units per acre. That's correct.
Yes,
Okay.
okay, there you go, that answers yes.
Okay, we
Because
just
if you
wanted-
see, that's not in any of the approach map of either one.
Right, and that's what I understand.
Okay.
We were just clarifying that the noise is less than 0.65 decibels there. There is a portion of the property that is eligible for 9 units per acre.
Okay, yes.
Okay, thanks, Mr. Peter.
Thank you.
Mr. Fife, do you have anything you'd like to add?
Thank you.
Yes, and we would like to, we are currently forming a new noise study right now. And we would like, and the video of aircraft flying over that area, we would like to submit that here as soon as they're complete. They're doing it right now.
Is allowed to submit what you've got until right now.
Okay,
Not to submit it later on as you,
okay,
I mean, because we have to take the information.
correct, yes.
Number one, we have to look at the date of the application. Number two, we have to take the information and get in the hearing.
Okay, I'll check on that right now, thank you.
Okay.
Thank you. Randy Fife, my residence is 270 East 13th Street. I was born in Idaho Falls in October 1955, and I worked for the city of Idaho Falls as the city attorney.
We would call that a youngster. Some of us would.
So I appreciate being able to just a few things, and maybe I could start by trying to clarify. I talked to Mike Kirkham, the assistant city attorney, this morning, and asked him whether or not we had provided everything that we had that was requested by Mr. Sir and the county. He said, in fact, that we have. His explanation about why we don't have emails back and forth is twofold. One, there just may not be any. And also, we looked back to see if we had any historical correspondence. And he said it was probably before we archived our email. So if it was in an email, we don't have it. So you have everything that we could find. And I apologize that we don't have what may be out there, but we don't know what that would be either. So
Just so, I mean, I hope you can understand. the
Oh,
concern.
I do.
Zero correspondence.
we would like to see it too. We can't find it. We don't have it. Well, I don't have an explanation other than Mike spent some time on it, and I wanted to verify it today so that you had everything that we could find. He said there isn't any more that he can find.
With anybody. on
That's
these
correct.
Properties or anything in this area. Okay.
That's my understanding.
Okay, go ahead.
A couple of things I just would point out, just to have you consider deliberations. One is that because we are the airport sponsor, we are beholden to the regulations of the federal government through the Federal Aeronautics Administration. And some of those regulations aren't necessarily intuitive or consistent in our view. However, we're still responsible because of our contracts with them for having received money to develop the airport to administer to our best ability. So when we put the moratorium in place, it was to try to understand them and then to minimize their impacts on development, because the city is interested in allowing development as long as it's responsible, which is the same charge you have in the county. Unless you secure a property, it's my understanding of the law that unless you secure a property interest by coming to an administrative body and altering your relationship based upon their regulations, you don't have anything that's what you call grandfathered. You don't have pre-existing rights. You just have what you have. So at this point, it's my understanding that the piece of property that's in question here is agricultural. Anything the city would do when its own zoning has no effect at this point on this piece of property because they aren't annexed. Now, if they were annexed, it is correct that the city's jurisdiction would then apply and the processes would apply. But at this point, there isn't a takings or regulation through the city that I think can be legitimately asserted against the city. Whether that's true because of the county's position in its area of city impact adoption of city regulations is a different question. Now, we also work for the city, and the city has a policy based in part upon criticisms and comments that the city was an irresponsible annexer. And they developed a resolution, which I know that the commissioners are aware of, that tell us when and how to annex as a general rule. We also have an open door policy at the city, as long as I've worked there, where if somebody wants to come in and discuss annexation, we are interested in that. Occasionally they will say no, that that's not appropriate, and occasionally they will say yes, and we'll work with anybody who wants to annex. But at this point, the city has not been interested in aggressively annexing all properties that are annexable, but simply within the last year or so, pursuant to the resolution, those that fit within those parameters, and that's a staff question. So maybe that will help us discuss that. There's been an allegation that the city's only interested in money, and it's simply an economic driver that the city cares about the airport, I would strongly disagree that that's the case. Transportation in and out of the city is important for safety reasons, for national security reasons, for support for the county and out-of-county businesses, including the INL and those supporting endeavors here within the town. There are people who work at the airport, there are people who are farmers, there are people who just live here who use that airport. And part of what the airport does is put the city in a viable position to be able to both maintain what it has now and to develop those things. And I say that not as a way of a commercial or a pitch, but to simply say that there's a regional interest in that airport that's far beyond what the city might get in grant assurances obligations. As part of that, and as a highlight of what the import of an airport is that cities can annex land outside of city limits and outside of the state of Idaho to construct and maintain airports. Now, I want that to be clear because there has been a discussion about the what's commonly known as the North Loop litigation that you may be aware of. It says that cities can't annex outside of city limits unless there's a specific allowance to the city granted to annex. And if you'll, for the record, want the reference, I will say that in the Ninth Circuit case, the Ninth Circuit quotes that the city has, let's see, likewise, section 21401 authorizes municipalities to acquire by condemnation land either wholly or partly within or without the boundaries or corporate limits of the municipality for purposes of constructing and maintaining aviation fields, airports, hangars, and other air navigation facilities. So the city has had conversations and continues to have conversations with the applicant to try to figure out whether there is a resolution whereby the city will acquire that land pursuant to the authority specifically granted to it in Idaho Code 21401 and specifically referenced in the Ninth Circuit case that we're all aware of. So I just want that to be part of the conversation to make sure that these allegations of bad faith or economic drivers aren't misunderstood between the parties and the decision makers. We will continue as the city to work with the property owners to see if there's some other resolution, but relative to the zoning, I would just point out that the city's interest is far beyond economic. There are people who use that airport. It's also, it does have great economic value to the city, but then the city has decided, as well as the county has decided, to support the airport by putting that as part of a feature in their comprehensive plan. So those are the kind of the things I just wanted to highlight here. There's things I can help you with. Other than that, or questions to answer?
I got a question. I go back to has entertained purchasing that land the past 10 years. And if
An offer's been made and rejected. And it was based upon the federal land acquisition rules, which require that there has to be a capital improvement plan, which we submitted to the FFA. FAA, the FFA probably doesn't have enough money, but the FAA, and then it goes to they have to be an appraisal by a federally approved appraiser. After the appraiser is done with the first appraisal, there's a separate, under the federal code, a separate appraisal that then reviews the first appraisal to make sure that it's within the limits and guidelines of the federal appraisal guidelines. And after that, then that offer is made for full value of the appraisal to the property owner, and that has been done. The property owner, I don't know if it's relevant here, was pointed in their opinion about the appraisal. We have also reassessed that, and we fully anticipate that there will be another discussion with a view toward trying to acquire the property. But that's irrelevant in a sense. It may be, though, that the applicant would not be the owner, it would be the city. And then, of course, if negotiations, according to this federal code, aren't successful, then the airport's authorized to use eminent domain powers if the city chooses to. And as I quoted here in the Idaho code, it has the authority to do so.
Follow-up question.
But that's probably irrelevant to the rezoning, but it had to do with the background you asked.
I have some other questions too on that specific.
Yeah, I have some understanding of the North Loop situation, and I do remember that as part of the finding. I didn't remember that it was for, I knew it was for building, but are you saying that it includes clear zone as part of it? I may have missed it.
Well,
Construction of, does that include clear zone?
well, it says in relevant part, for the purpose of constructing and maintaining aviation fields, airports, hangars, and other air navigation facilities. It also includes providing equipment necessary or incidental to the maintenance and operation of such aviation fields or airports to maintain, operate, and manage such aviation fields, airports, and grounds. So I would assert that it would also allow for the maintenance of what is currently owned, but if you purchase it with FAA money, according to the land acquisition rules, then that would become part of the airport and you would be able to maintain it. It includes putting transponders out there, additional lighting, some buffering or baffling. You could put some weather stations out there, all the things that are compatible with a more pure airport use than what would be included in residential development or incompatible development. And the reason why would be to not have those kinds of interferences. And the FAA has said okay and given us the money to do it. So I think that it's not just a wish or a desire to, it's in the capital improvement plan. And so I think that's, I don't know if that's helpful, but I hope it answers your question.
Thank you.
Yeah, because that, would you
Now, mine's marked up as you can have it if that's okay.
or just leave us the.
Yeah,
site,
sure.
citation.
You can give it to me.
Okay.
And this also referenced the Ninth Circuit case.
Okay. Okay, so I'm trying to reconcile two different things that you brought up. One is that the city wouldn't have a takings issue because you're not making a regulatory decision because it's in the county.
I think a lawyer could probably make an allegation like that.
Well,
But our answer is we have no authority over them.
and then when you start talking about the statute that you just said, it gave you the option to go do a regulatory taking.
No, not a regulatory taking,
Well,
a purchase.
combination, that's the same thing. Distinction without a difference.
Well, to me, no, to me, they are different. But
Okay.
yes, it would allow you to acquire it in whole,
Okay.
which then, yeah, yes,
Okay.
we
Yeah.
can mince that around a little bit, but yes,
But
we could acquire it.
I just wanted to reconcile in my mind because the task before us is the rezone, which you pointed out.
Correct.
The litigation, if there is any condemnation, would be between you and the applicant.
Right, or the purchase would be too, either way.
So, our main responsibility is to make sure the county doesn't do an unjustified regulatory taking that has to meet within whatever conditions we feel like meet that zone.
Agreed.
I just wanted to clarify that because I got puzzled because you were heading down one direction and then jumped.
There was an allegation made at the previous hearing that we were acting in bad faith and trying to take the land and asserting our rights where we shouldn't. And I just wanted to be clear in the record for rehearing, since it wasn't recorded, that our opinion that those are incorrect and we would disagree with those.
And that's fair. Okay, that's the only question I have. So,
No.
okay, we'll offer Mr. Johnson, if you go past the 3 restroom break though, we're done, so one more 60 seconds.
Is that a senior moment?
If I didn't have this happen, if anybody else needs to sit out here.
I'm happy we take a break.
And prior hearings, we allowed our planning and zoning, building and zoning administrator to get on the record things that they felt were relevant. I think Steve has probably given you a list of those, so if you want to go ahead, Austin.
Go first. So one of those things that we needed to get on the record was brought up in a question earlier. That was just the question about the area on the property that was in the limited, called exactly here, the limited development zone that under the Idaho Falls adopted ordinance, as long as residential densities or as long as the decibels are less than 65, the residential densities of less than 9 acres are allowed. So that was one of the things that Steve wanted brought up. A lot of the FAA things, the reasons for no residences and the report that was submitted from them, that was submitted in the previous hearing, it talks continually over and over again about the noise impact on the property, and we don't see how that applies to the property because the current noise study that was provided by IFRA shows that the decibels are less than 65 on the property. So we don't see how that is applicable on the property. Let's see here. So a lot of it was noise. Also in this document that was submitted, it says, it talks about obstructions, pre-existing obstructions. And then it says, if such obstructions are not required to be removed as a condition for a grant agreement, the execution of the agreement by the government constitutes a recognition that the removable is not reasonably within the power of the sponsor. Steve had a question that if that land was to be taken for the approach anyways, the approach surface, why was that not done at the time that the airport filed all of those things as part of their taking when they came in and looked at all of that property? Let's see. And then the only other thing here is Steve just wanted to recommend and have put on the record that if it came to the point of doing a taking, that a taking study was done in compliance with the Attorney General guidelines for a taking. And those were the notes that Steve had to share.
Okay, can I give the city, as I saw,
Sure.
questions on any questions or comments on what Steve?
I guess I don't understand the reference to taking, the city has taken nothing.
Right.
So,
That goes back to the conversation we had at this point. We haven't.
Right.
We would have to build.
oh, okay, thank you, I just was
He
confused.
just wanted it as part of the
Sure.
so.
Brad?
I guess my question, since those questions are coming from the zoning office, so I can think through this, how those questions are relevant to requested. So
I think these are a summary of what was on the record on the last hearing that they recalled that they wanted on the record this time, since we don't have a transcribable record.
okay.
That was their recollection of things they wanted to make sure were included.
That's correct, and the reason for the looking at the development and the density is because what the applicant is applying for allows more density in the area. It also just one other thing I remember to put on the record, there has been existing development of ag plots on that property. So this development, according to Steve, is really a continuation of development on the property that had pre-begun. The reason for the density talk about the 9 units allowed per acre below 65 decibel is what the applicant's applying for is less than that. And there is some area on the property that allows for that type of a density under City of Idaho Falls comprehensive plan for the airport overlay. So
Anything else?
I think that's it.
Okay, now, Mr. Johnson.
Okay, thank you. You know, whenever I hear the words, "it is clear," that's always a buzzword in court when I hear that. Because usually when it is, it's usually puffing and it isn't as clear. As they say, Mr. Kramer made the statement, it's clear that the property qualifies for annexation. No, we differ with that. It is not clear. It is not subject to annexation at this time. The argument that was made is that, well, first of all, there's no plat involved. One of the key legislative changes that has taken place in recent years is Title 50-222, which is that basically is that in order for an annexation to take place, and I believe it's under classification B, is it has to be acreage of less than 5 acres. At this particular point, there is no such property pending before the commission. And it is not clear, and in fact, we disagree that it is subject to annexation. Thus, the area of impact is not applicable in this particular area. There's also discussions as far as the city's responsibility, as they call it, as an airport sponsor. That is a voluntarily assumed responsibility that they have by taking federal aviation funds. Now, we're not attacking the airport. We're not attacking that it should go away. We're not saying that they should restrict its use at this time. What we are saying is the fundamental principles of taking of condemnation, and particularly in the taking, is as long as you're not interfering with your neighbor's property, then there's no taking. And that's really what we're talking about in this case. I do agree with Mr. Fife that the city is not subject to any regulatory taking at this point, because the regulatory agency is this body at this time. It was Mr. Kramer that had suggested that this court defer to the city and to require us to go to the city, request annexation, at which point they would become responsible for a regulatory taking. I do agree, and I would say that Johnson Legacy and the members of that are committed to negotiating in good faith with the city to see if we can get a resolution. But at the same time, we're still moving forward with the hope that we can get that resolution. Now, Mr. Fife talked about what is known as the Uniform Relocation Assistance and Land Acquisition Act policies of 1970 is the official title of that. Under that particular provision, which there could be used for funding, is that there is no negotiations that are possible at this stage. In order for that to be fulfilled, it's basically based upon an appraisal that the city themselves choose of a reviewer that they choose and submit it to us. We do not have any options of submitting any counter proposal, of having our own appraisal done at this particular point to be considered by the FAA. That can only be done if there is litigation committed, and then there's negotiations at that time. And so I think it's clear, but I want to make sure it's very clear, is that there is a difference between regulatory taking and condemnation or eminent domain. The city has the obligation not to follow the regulations, but in order to acquire the FAA money is to acquire sufficient property for the safe operation of the airport. The problem that we have is they're trying to defer that onto us and to say that we cannot develop our property because of their use. And so that's where it becomes the issue of what is our responsibility, or what is this commission's responsibility in order to move forward. Now, let's go back to the very basic tenets of why we're here. And that is that it's a policy of managing property in a responsible way. We have submitted evidence that shows that what we propose is consistent with the usage of the land. What we've heard from the city is unknown, it's void. That they have not presented a single compatible use that is viable. Previously, they have said that there's 50 uses. And we pointed out, obviously, because they make good poster children, schools and hospitals as being those uses. But as we hear today, we don't even know even what of the remaining, quote, 50 is remaining. And we certainly have not heard anything that would be considered as viable. Now, they make the argument of access, and it's an interesting, and saying it's a half a mile off the road. First of all, let's compare that to what their arguments are. For whatever 50 uses that are non-residential that are, quote, off the road, how many of those are viable? How many commercial buildings want to go a half a mile off the road? How many schools will be half a mile off the road if we use that same type of analogy? In conjunction with that is that there are people that don't want to be in the city of Idaho Falls. The fundamental concept of value in real estate is location, location, location. And in this particular situation is we have prime real estate located on the scarcest resources in Idaho Falls area, and that is the Snake River. Highly viable. And yet we're saying that, well, because of the city gets money, and I understand the regional economic impact, is that we need to forego all of that and just leave it as open area or leave it as farming. But let's look at some of the arguments that are made. Is they talk about this being noise control. And Mr. Collier talked about 14 flights a day. So if we take 14 flights a day and we assume that each flight that goes over, and I think of being very generous, takes 30 seconds, we're talking about 7 minutes a day. And that's a tail wagging the dog. Now, obviously, the solution is for us to come up with the city and the landowners with a solution. That's, I think, a moral duty. It's not necessarily a legal duty. But other than that, and I think it's for them to acquire it. I think that's a very viable choice. But this body, I don't think is necessarily in the position to say, to direct the city. I don't think this is an arbiter of any dispute between us and the city. This body's responsibility is to make decisions, and I would submit it is in the highest and best use of this property. Now, the questions were also asked about the time period. I've attended about every public meeting the city sponsored, their planning and zoning, their city council meetings, and it was discussed in several of those of the need and understanding to cooperate with the county. And yet, even though those discussions took place, there was never any outreaching to the county at any of those times while the process was being done. So, I guess more as a private citizen, there should have been the dialogue when it was known that the county would be eventually involved in this. And this is the difficulty. True, the moratorium was only for 6 months. But during that 6 months, we have always been available. We've had meetings. Mr. Kramer has always been very cordial. We have a difference of opinion on that. But as far as the availability, We've always been available. I would note that we did talk to the city in 2018 about the possibility of development. We didn't submit anything, but we did present some preliminary plats at that point, but were rejected, or because of apparently the pending moratorium coming up. As far as documents from the FAA, I don't know if there's any emails or text messages. I would believe that maybe the commission wants to look at the audit reports that the city may have, because that is what in essence triggered, as I understand it, the moratorium. And on that, and this ties into some of the comments or questions by Commissioner Reed, is that the part of the audit is the city was allowing development in areas that should be controlled. So if you look at these noise corridors or the full engine for 10 miles out, you know, one of the class 2 examples that I could readily think of, one is Fairway Estates. It's a shoestring annexation at the time that it came in that is approximately, I think, 1.25 miles away from the edge of the airport. And we have flights going across there all the time. We have Heritage Hills that was also part of this zone restrictions that was allowed to be developed. So when we look at lighting, it is, I think, one of the things that we could look at, and I think we look at it down the road, is they talked about a 400-foot strip that would be clear. So if we're looking at the argument that there is light interference and so forth, there are feasibilities of looking at those issues and addressing those to balance between private owner and governmental interest. So, so it's kind of frustrating when they're throwing in these arguments in order to find something that sticks, that there's ways that we can perhaps address those issues as part of down the road versus what is being requested is an absolute barrier to development in this case. In conjunction with the questions as far as the sliver of land, I would note that just for the verbal record that it is a narrow triangular piece in the north central part of our property that is far removed from any of the edges that we would have access to or to build property. And it also consists of a very small portion of that. I would also believe that it would be important to note that the uses of the city are inconsistent with what the county currently has. And we believe that the county's is still viable and applicable, and particularly as it relates to residential property. Thank you. Are there any questions?
Just one, the audits you referred to, can you give us a reference where to find those so we can put them on the record?
I would ask Mr. Collier if he's aware of those. I was going to do a Freedom of Information Act, but I do not have those.
Do you have a copy of
I
those
don't know,
audits?
he's speaking of audits, I guess I don't understand what he's trying to make reference to.
My understanding is in some of the city meetings is the moratorium came about because of a FAA audit. So you're saying the FAA does not do audits?
Yeah.
I'm not aware of what he's speaking of, I guess.
Okay.
What he's making reference to.
But if it's your position that the FAA doesn't do an audit like he's referring to?
The FAA does audits, but not in reference to what he's speaking of.
What type of audits do they do?
We do safety audits every year.
And did any of those safety audits refer to what?
They don't even look at those type of things. This information was given to the council by the FAA representative. And in a meeting, in a council meeting.
Okay.
It seems odd to me, and I think we ought to have a clear record from the city, is that there is no documents of any type that relate to the policies or directions that the city is verbally representing to this commission.
We'll review what they put in, see, and that this isn't addressed to you, but it did bring something up that I want to clarify, Mr. Five. A statement made, I'm sorry, about how, okay, we'll see. Oh, on annexation, made a statement that we are aware of the policy the city has on annexation. Yes, we are aware of that, and well, we've been aware of that. It's been a work in progress and it's changed a few times. That does not imply that we agree with everything in there, as evidenced by us trying to get back together, which kind of goes with what Dave is saying, with the city, a request to meet with city council to continue that. We haven't been successful in getting that scheduled, the direct meeting with the city council, but you do have an annexation policy, we agree.
It's a resolution. I'm not saying that you do or don't agree with it. I just wanted to be,
I just wanted to
be clear that there is one, and staff reacts through that resolution. Right. But part of the policy that staff has is anybody who wants to come talk to the city about annexation is talked to. It does, though, set parameters that, for example, distinguish between category A annexation, which the applicant certainly could apply for, and category B, which is more reluctantly exercised by the city. And that's part of the origin of that internal city look at annexation, so that we can be predictable. But I agree that that doesn't mean that the county commissioners are bound to it in any way or agree with it.
Okay. And it also does not include the other categories of annexation, which you referred to as involuntary change of governance. We call them forced annexation.
Well, I mean, some people call category B forced annexation. I don't call it that.
I know.
I call it the exercise of legally granted authority to the city through Title 50.
Very excellent lawyerly distinction. Yes, state your name again.
Ryan Loftus, Aspen Engineering, 10727 North Yellowstone Highway. In table 11 -5-6, it shows both the limited development approach surface and the controlled development approach surface. And with regard to the 65 decibel 9 units per acre, it doesn't apply to the limited development approach surface, which is the Johnson Farm. It specifically prohibits any dwellings, either accessory units, multi-unit, single-family attached or single-family detached or 2-unit. And so if we could just, for the record with the map, show that 65 decibel exclusion doesn't apply per the city's adopted comprehensive plan.
Could you submit that just so it would be easier for us to find?
Yep.
Okay. Who do we have? How many do we have on Zoom? I can't see a couple of them. I think we have Ruby as the one.
The Bensons are my relatives.
The who?
Cecilia Benson, that's my sister.
Okay. Does anyone on Zoom wish to testify, add anything to the public hearing? Yeah, shaking no. The nice thing about Zoom is this preserves a video record too.
Well, I don't know if anyone knows, but they are on mute too.
Yeah, that's why they were shaking their head. Okay. Any other questions? Anything else? Yes.
We have one more thing, an explanation from.
We discussed the noise study and the video of the aircraft over that area. Unfortunately, today, the aircraft is not going to be here in time, so we won't have that.
Okay, thank you. Okay, with that, we'll call this hearing public hearing to close, we'll take the issue under advisement. There's quite a bit of record developed here that we're gonna have to sort through. We've sorted through it a couple times, but now with the additional information, we'll try to get some proposed findings as soon as possible. With the COVID thing, sometimes that's a little unpredictable, but staff was working hard. We'll put that on the agenda. Usually we do that at the 9 o'clock administrative, so we have a 5-day requirement with a 48-hour notice. That'll be a public hearing, a public meeting, but not a public hearing. So you're welcome to attend. The instructions are there by Zoom, but there will be no public input on that. So with that, we stand adjourned. Thank you. Back to my budget. It's almost as coming.